On the contrary, no civic education was conducted. There was no material evidence accompanying the allegations. There was no opportunity provided for the Kenyan people to seek clarification on the issues raised on the form provided by the National Assembly as a template for public participation. This resulted in an obvious information bias, the danger of a single narrative, exhibiting the inadequacy of the process. My lords, my lady, in regard to the second question, I presume, my lords, that reason would have to be extinguished from the word for a public gazette that was issued on 5th of October 2024, and subsequently, on the same day, a public participation undertaken for it to be deemed as anything reasonable. My lords, it is the height of blatant contempt dressed as compliance. Courts have ruled that conduct calculated to defeat the purpose of court orders amount to contempt. I refer you to paragraph 31 of a written submissions in Samuel M. Mweru and others versus National Land Commission, and two others, 2020, KEHC 9233 KLR. The High Court stated that contempt proceedings vindicate the broader public interest in obedience to its orders, since disregard sullies the authority of the courts and detracts from the law. My lords, pertaining question 3, your brother went into the trouble of quoting the Supreme Court in the famous case of BAT. He was very express as in regard to what required to be done pertaining the public participation, that it left no question whatsoever to what the National Assembly was expected to do. The qualitative and quantitative aspect of the public participation. My lords, allow me not to quote the BAT case. I know it's already on your records, but I refer to it in regard to this. Would demand, 1, adequate information provided to the Kenyan people, which was not provided in this regard, and sufficiently reasonable notice issued for them to be able to participate, both of which are lacking. It is therefore my submission that on the test of the 3, the purported public participation carried out by the National Assembly falls short of anything that can be deemed qualitative, quantitative, reasonable, and adequate. The National Assembly, my lords, cannot use Order 64.2 of the Standing Orders against constitutional protection of Article 10 and 118 of the Constitution of Kenya. Article 2.4 is express as to the supremacy of the Constitution in light of any other law or any other provision that is deemed to be contrary to the same. Allow me to refer you to paragraph 96 of our written submissions. And in specific, the matter in Orange Democratic Movement Party and 4 others was a Speaker of the National Assembly and 5 others, Constitutional Petition E491 of 2023 and E10, E025 of 2024 consolidated, and the rest, Your Honor. To save on time, In verbatim, the High Court held standing orders were procedural rules which guided and informed how the National Assembly should, at a minimum, conduct its business, including public participation. Standing orders did not, however, override the Constitution and were not a substitute to constitutional edit on public participation as expounded by the courts. It is therefore clear that should there be any conflict in regard to the standing orders of the National Assembly and the Constitution of Kenya is supreme. My lords, my ancestors are talking to me. My lords, paragraph 97, my lords. In Kenya National Commission on Human Rights versus Attorney General and another, 2015, 7634, the court held that the jurisdiction of the court to invalidate laws that are unconstitutional is in harmony with its duty to be the custodian of the Constitution, which promotes its supremacy at Article 2 by proclaiming at Article 2.4 that any law, including customary law, that is inconsistent with the Constitution is void to the extent of its inconsistency. And any act or omission in contravention of this Constitution is therefore to be deemed invalid. My lords, Article 150, as read with Article 145 of the Constitution of Kenya, does not expressly limit the time within which a resolution for impeachment must be arrived at or concluded. Standing Order 64-2 therefore lacks constitutional bearing and is subject to judicial review by this esteemed bench. Its constitutionality must be examined under Articles 2.4, Article 165, 3D of the Constitution that gives this bench the authority and the jurisdiction to interpret the same. My lords, it is my submission that demonstrably public participation purported to have been carried by the National Assembly is, for want of a better word, a symbolic affair. It was a display of the fallible nature of our attempt at democracy as a nation, and if the apparent manner in which it should have been conducted was clear and loud from Justice Mwanzo's orders, perhaps then the prevailing circumstances of a premeditated, politically instigated process, it could have fallen, or the orders of Justice Mwanzo could have fallen on deaf ears. With no shield under Order 64-2, the National Assembly is therefore exposed for what it exhibited as a lawmaking body that does not obey the law. This must result in an outcome that cannot stand in a constitutional democracy governed by the rule of law. Allow me to refer you to paragraph 33 of our submissions in the matter of Mark Foy versus United Africa Company Limited, 1961, 3 ER 1169. The very famous Lord Denning, who was as classic as the good professor of law, Gideon Wegai, held that if an act is void, then it is in law a nullity. It is not only bad, but incurably bad. You cannot put something on nothing and expect it to stay there. It will collapse. Any subsequent actions undertaken by the National Assembly based on the null and void acts of the purported public participation must therefore collapse. They cannot hold in law. Blatant disobedience of the court orders must be rendered null and void ab initio. My lords, my lady, I think I've kept my time. As the Latin maxim goes, fiat justitia ruat caelum, and for the benefit of our lay friends, let justice be done though the heavens fall. My lords, I will not proceed beyond that. And, the good Senator Agenda was muttering something when I said that I have my sisters, my learned sisters here. Yes, they're my sisters, Senator, but they're not available. Thank you, my lord. I hand over to my colleague, Mr. Muge.
Thank you. You are smart on time. We hope that subsequent parties will observe that trend which has been set. You asked for?
I had asked for, in total we're supposed to have 1 hour. She's taken about 10 minutes, I think.
25 minutes.
25 minutes. I'm going to take a much shorter time. I have agreed with my senior, Mr. Kibe, that I will be not donating 30 minutes to him.
Okay.
So, my lords and my lady, I proceed after my learned colleague, Ms. Maina, and I am in the unfortunate situation where the gravamen of our petition